you were talking about getting an attorney, and you said things about that in the past. If you can give us an update, do you intend to be represented by a lawyer or?
I do intend to be represented by a lawyer. My benefits do not kick in until January. I've been trying to reach out and find a lawyer. I currently don't have very much money at this point to pay for a lawyer, so I'm trying to pretty much depending on my benefits.
All right, well, as it stands now, you're here today without counsel again, and that's fine. You can represent yourself, but you have a motion to reopen and to extend discovery that we'll have to talk about. And Mr. Needham, you have, on behalf of your client, Ernest Del Casal, a motion asking for a settlement conference. So let me go ahead and talk about that first, I think. As far as by way of a policy that I think makes sense after the 9 years I've been here, when lawyers come in, or those not represented by counsel for that matter, come in and ask for settlement conferences, of course, my mindset is to always try to find a way to support that, accommodate it, and to the extent a court order is necessary, give that to you. Consistent with the idea that settlement's a wonderful thing for everyone, mainly because it resolves the situation and you can move on with your lives. However, if it appears to me that the actual settlement conference itself would be a waste of time, essentially, and futile, then typically I wouldn't order people to go to it, because as we all know, at a settlement conference, there's some requirements. You have to file a settlement brief ahead of the settlement conference, which of course takes time, effort, resources, money, and what have you to put together. And then you go to the settlement conference, and that's time for a settlement judge, whether it's a regular judge here or a senior judge. And that is an effort that takes also usually about at least a half a day or 3/4 of a business day. And so, again, I don't want to order people to go to settlement conferences if it really appears as though it's a waste of time, essentially. So I'm all for the settlement conference idea, unless I'm convinced that this would be a waste of time. And so that's what we would want to talk about having to do with that. So let me start with you on this then.
Thank you, Your Honor. And I understand your points you just made. Settlement conference is a widespread concept, and probably at all the courts out here at every level. And I've also heard sometimes you argue this would be a waste of time, and there's percentages of whether these conferences are successful or not. Some will say we have 50% success rate, 80% success rate. Sometimes they fail, sometimes they don't. On this particular case, at the last hearing, Mr. Harris complained to Your Honor that this is very troubling. He's very stressed. We also heard that Mr. Franklin didn't have an attorney. There's financial issues. I felt this looks like a good idea. And it doesn't seem like there's anything to lose. I think in this particular type of case, unlike all the other ones Your Honor heard today, this is there's negative emotions here. And I think it looks like it may be the best method. That was going through my mind. And so I thought it was a good idea, and I thought Mr. Harris would actually embrace it, at least give it a shot. Yeah. Not just have this assumption it's a waste of time. Because, and instead he filed an opposition the next day. And it's probably because of a lot of this negative emotions. I still think to this day it's a good shot. I just think in the right environment, these parties probably can resolve this dispute. That's all I have to say.
Okay, on that point, something does come up, I think, at least philosophically from Mr. Harris's point of view. And that is, where's Mr. Del Casal on all this? He hasn't, I think what you're saying pretty much is he hasn't been around the court. We haven't seen him here much. He's, according to Mr. Harris, the reason I think there's an opposition to the settlement conference idea is that, well, is Mr. Del Casal going to participate essentially in good faith? That's my paraphrasing of it. And so before we turn it over, maybe even to Mr. Harris on that point, can you tell me, if I order this, what's Mr. Del Casal going to do to participate in good faith?
Well, we'll say two things. We did mention this in the paper, that there was been some offers to settle, so one of which was by Mr. Casal. I
Yeah,
made
no doubt, in July,
Yeah.
in July of this year, the plaintiff made
Right.
an offer, and then you, I think, I don't know if it's a standalone offer or counter offer that comes about 4 days later, right?
Yeah,
On July
and so
22nd.
I talked to Mr. Casal, got his authority, made it, obviously didn't settle the case, but there's one effort on his behalf to give me that authority, so there's one thing. Number two, it was just filed a couple days ago, or maybe even yesterday, the stipulation order regarding an injunction, so I put his cooperation on signing Mr. Harris's, status quo type of restraining order, so he's cooperating in that regard, and then in that, it says he won't make any negative comments. The concern with that was, he said he was concerned about signing it, it's almost like acting in admission of liability. I actually had Mr. Casal actually sign the stipulation, which is a little unique and unusual, but I wanted him to personally sign it. So there's 2 points in response to the judge's question about Mr. Casal's efforts and cooperation he's done. Those are 2 examples.
All right, well, just on this point, let me go to Mr. Harris then. Just on the idea that Mr. Needham thinks that a settlement conference would not be a waste of time, and it could potentially resolve the case. And it seems like what he's basically saying too is that his client will participate in good faith. So what do you think?
Well, just a couple of things, Your Honor, and I do appreciate your time today. I think that it is a waste of time. I do not believe that the participation would be in good faith. That is predicated upon the fact that Mr. Del Casal has entirely denied any and all responsibility for the publication or for the authorship. So I don't understand the connection between how I'm going to go and participate in good faith when I've told you 100% I've had absolutely nothing to do with this. So I don't really know where we can go at that point. Why would you take a step back and now say, well, I'm going to now confess that I have? When your position is you had nothing whatsoever to do with it, there really isn't anywhere to go with a settlement conference. And so I don't really believe that it would be fruitful. I think it would be an utter waste of time. I do not want to go to trial. I do not want to continue to waste my time and my resources on this case. And I think settlement would have been amazing. And but to say that there's been an offer, to me, an offer was they take judgment against me. I mean, I don't look at that as an offer. And with regard to the stipulation on this, we agreed to that stipulation on March 5th of 2019, and I can't get that signed and filed until November. And somehow, we're supposed to believe that they're acting in good faith. It takes months and months to sign a stipulation that you agree to in court, and now you say, well, we're in good faith. We want to go before a senior judge and see if we can discuss settlement. And there just isn't anywhere to go with it, Judge. And I guess that's really what my problem with it is. In addition to that, appearing at what was scheduled to be the calendar call, I believe, but that on October 31st, 2019, we're here for a motion, and we set trial, and everyone agrees to it, and the next day, I get this motion on November 1st. And I just don't believe it's participating in good faith at this time, and I just don't think it would be fruitful.
Okay.
Thank you.
You want to say anything else in support?
Put some reasons for the stipulation. At the time the original was drafted by Mr. Harris, that's in regard to the injunction. There was some language that it was almost like admission of liability. But at that point, Mr. Flanagan wasn't involved in the case yet, so I suggested to Mr. Harris, let's see what's going to happen with this. This could all fix this could fix the case, so we put that on hold. And ultimately was signed. Ultimately, the stipulation was signed, and I'm not sure why we signed on about a month ago, and there was some delay in filing it, but the website in question apparently has been taken down. And that was before the lawsuit was filed. So there's nothing appear to be active right now in regard to the website. Mr. Casal has signed a stipulation saying he's not going to make any negative comments. So it seems like he's done everything that Harris wanted. He ultimately wanted Mr. Harris to say, stop saying stuff about me. He's done so. So it seemed like we resolved Mr. Harris' concerns regarding Mr. Casal.
And that's not true, Judge. The website is back on the air. It is back up. It has been republished, and it is out there. Again, now it's not the same content, but they're back at it.
can't order a change of custody if she follows the right procedure.
There must be an evaluation of the best interest.
You're going to convince me to hold your client in contempt.
Raise your right hands, face the court clerk to be sworn.
Sitting judges get contempt wrong all the time.
I find you in contempt. I am going to incarcerate you.
Any statement that you make is under penalty of perjury.
No, that's not how that works.
All right, well, let me turn to Mr. Franklin. I mean, it's an interesting little situation here, Mr. Franklin. On one hand, I always want to give people an opportunity to get an attorney if they come into court and say they want to do so. I think you told me that you wanted to do that by November the last time we were here, if my memory serves. Is that about right, or no? I think you said November.
Well, I didn't have any funds to get an attorney by
Okay,
November.
but now you're saying
my benefit-
January, essentially.
Yeah, because my benefit, well, when I found out my benefits, they do not kick in until January. So there's really not much that I can do at this point until January, until.
Right, so that brings me to something then, and that is, of course, you have a motion here asking for sort of a discovery extension. And do you want to make argument in support of that, or is your request to have an attorney represent you to further deal with that issue and any other issues in the case?
Well, I do want to make an argument towards that. There's been a lot of allegations put towards me, and a lot of false allegations towards me. So I do want an opportunity to be able to defend myself and do discovery and get admissions, interrogatories, and production of documents for the content that was posted, because of the information, he's saying that there's a lot of false allegations, that there's false things in the information, but we would like an opportunity to prove that it's either true or a matter of opinion. I want an opportunity to call witnesses. I want to, the motivation of him filing this lawsuit is really his illegal and unethical practices of his business being exposed. So that's why he's trying to silence the information. The information that was given to me, pretty much being a whistleblower, information of a whistleblower, and it's the public's right to know this information. On my part, there was no real wrongdoing. I didn't do anything wrong. I got some information from a client. I posted the information. Like I said before, the client did not pay me. I took the information down. Next thing you know, I'm involved in a lawsuit. So I would just like just the opportunity to prove my case and dispel all the false allegations that are against me, saying that I committed theft.
All right, let me talk to you for a second. My thought is that there's sort of a, if you think about it, it's sort of like there's a spectrum here when it comes to people coming to courtrooms and saying, well, I'm going to get a lawyer, give me time to get a lawyer, I want to get a lawyer. In other words, I think that what a court should do is you start off with the idea that, of course, you can give fairness and time. We call that due process. To an unrepresented party in a lawsuit, to get a lawyer. And I hope you know, I do that. I've given you at least one or two opportunities to tell me what you want to do in that regard. You said, I want to get, no, I've even, and I've had patience with that. To get back to this idea, when you start over here, you have patience, fairness, and of course I do that. But somewhere along the way, I have to balance that, of course, with the rights that others have in the case too. And temper your request with that of fairness to try and get the case resolved. And that really is something that where I have to consider the fairness to the plaintiff's side in this. And here we have a firm trial setting, don't we? For January 6th of 2020. That's it, right? That's the firm setting. And so today is, hope you have your Christmas shopping done, because we're 1 day short of 2 weeks before Christmas. So that trial setting is right around the corner, right? Come on. So if I give you more time to get a lawyer and maybe even have that counsel get involved with these discovery requests, I mean, clearly it's going to make it such that I have to move this trial date. There's a settlement conference request. Even that might reasonably mean move the trial date under the circumstance, it seems to me. I mean, I don't know, under the normal settlement program, there's no way to get a settlement conference done that quickly. For all I know, the three of you wouldn't mind moving the case anyway for whatever reason you might have. So let me at least ask that. Is there a thought that I should continue the case to deal with the issues that we have, or any other reason that everybody agrees to? Do you want to move this case or keep it where it is?
I'd like to keep it where it is, Your Honor. The reason being is that the website's back on the air.
All right. Okay, anybody else want to say something relative to anything that's on the table here today? Mr. Harris, you haven't really said a lot about Mr. Franklin's requests, which are really twofold, I think. One is give more time to get a lawyer, maybe till January, which means probably continue the trial, practically speaking. And then the other request is, without counsel here to argue that, move out the discovery schedule that will allow participation with discovery. And as you know, I'm sure you know, and Mr. Franklin may know, the legal analysis having to do with that would be good cause plus excusable neglect under the law. So if you want to say anything about that.
Just two things, points, Your Honor. On July 26th, 2019, you specifically discussed the attorney with Mr. Franklin and specifically went over that with him, just as you did on October 31st. And it was good advice on both occasions. And there's been no movement on that whatsoever. And I do not believe that it is a good faith request with regard to obtaining counsel, and I do not believe that that would occur one way or another at this point. With regard to the motion to reopen discovery, Mr. Franklin, I think it is relevant to note that there were some correspondence went back and forth between us prior to the filing of the amended complaint, that he was noticed of the supplemental joint case conference and did not participate, did not appear, that he was served with discovery from my office, which he responded to, so he was on notice that we were in discovery. He had every opportunity to avail himself of all the dates and deadlines. He had only but to ask. I've been incredibly professional with him, despite the fact that he's maligning me. But I have tried to extend professional courtesy to him. He's never asked for any dates, any deadlines, any information whatsoever. He's been completely uncooperative, and he's now filed a motion to reopen discovery and has not attached an affidavit, has not outlined what he wants, has not outlined the reasons why he needs that whatsoever. And again, he did appear at the October 31st, 2019 hearing and indicated he was ready to go to trial, and a firm setting was made at this time. The prejudice that would be undertaken is the same prejudice that is the genesis of this case, and that is that he continues to publish things online in cooperation with Mr. Del Casal or not. At this point, I am not sure, but he has republished, and it's on the air. In addition to that, after the last hearing, October 31st, he went back and pretty much admitted to all of the facts of the motion for summary judgment. In fact, posted and stated that him capturing the Google listing was a bold move. And so he's pretty much admitted to all the wrongful conduct at this point, and obtaining discovery for the purpose, for whatever purposes I believe they are, only just to harass me further and my family and my business. And there's no legitimate purpose, and he has not outlined any of that in the moving papers, and we'd ask the motion be denied.
Okay, anybody wants anything else?
All of this information that it is in the case. All of the documents that they have been filed. I've spoken about the illegal and unethical practices that were going on, which was documented. All of the stuff that he's saying is just untrue. So, like I said, I do need the case moved. I would like to hire an attorney. I'm at this point right now. The reason why I haven't, because I can't afford to. I've reached out to a few attorneys. No one has been able to take the case for me right now. It's definitely not on pro bono or anything like that, so I do need more time to get an attorney to at least fight for my rights, to show that the stuff that, like he said, I've admitted to the things that I've done. I've been honest about everything that I had involved with. I've been honest.
Part of me just feels like I should ask something that seems to be highly relevant here. Do you agree that there's some sort of reposting or information out there consistent with what Mr. Harris has said?
Reposting? No, there's no derogatory information posted. No, as far as the website is concerned. There was just a template of good information, pretty much. There's nothing bad about what's posted on legalrightsfordivorcefathers.com.
Okay.
Your Honor, I did have one point to make. In Mr. Harris's papers, he indicated regret that regarding this restraining order that it doesn't involve Mr. Franklin. So perhaps that's a possible way to resolve it. If there, I'm not suggesting any, but the current restraining order or injunction only involves Mr. Casal, does not involve any other Mr. Franklin. So maybe that's a way to solve this.
You know, it's interesting you mentioned that because what I had on my mind was something very consistent with that. And so, Mr. Franklin, my thought is if I were to give you more time to find an attorney, you've indicated in here that you'll have the financial wherewithal to do that in January, right?
Yeah,
Which is
I have a benefit.
Right?
There's a benefit. Yeah,
we're actually a few weeks away from January. That's what we are. So if you tell me you're going to get a lawyer in early January, first week of January, that could motivate me. Could you tell me that? Could you make an affirmative sort of almost guarantee that you're going to get a lawyer in that first week or so of January?
In the first week, I'm not exactly sure. The benefit.
Okay, let me ask you
because
that.
the benefits
What
start.
would you be willing to tell me that I'd hold you to, in fairness, under the circumstances regarding getting a lawyer? could you have an attorney that I can hold you to and proceed accordingly with, based upon you telling me this? When would that be?
I will be able to get someone during January. Soon as my benefits kick in, then I'll begin that process. I'm not sure.
Sounds like what you're saying is you want to the end of January
That would be,
to get counsel.
that would be.
Continue the trial. All right. Now, consistent with what we were talking about, I would say I would agree with Mr. Harris. I'm not going to continue this trial if there's any continued publication of an item that may cause harm to it. And, you know, it's not my province to figure out whether something does cause harm or doesn't cause harm. That's up to the finder of fact at trial. Okay? But I think a good practice that I would probably see lawyers involve themselves with would be to say, look, we'd be willing to enter into some sort of court order, an injunction is what we call it, where we would maintain what we call sort of a status quo, meaning there'll be no posting, no internet, no whatever it may be, no publication of anything while the case is pending. And if you tell me you'd be willing to do that, that could motivate me to give you what you want by way of some more time, continue the case. But I'm not going to continue this case if there's any chance that either Mr. Del Casal or you have anything out there being published. And let me just say one more thing about that, that I can't represent you as your lawyer, of course. But I think as a judge, I can say this. If you had a lawyer, chances are a lawyer would say, you know what, there's this idea of potentially mitigating any potential damages. And that's one of the reasons to enter into this injunctive sort of agreement. And that is because you don't want a lawyer representing you might say, you know, let's go ahead and take a conservative approach and just take things down, don't republish things, don't have anything out there on the internet, if you will, while this case is pending, because we don't want to even accidentally aggravate the damages in the case. And it shows good faith to do something like that. It's probably another thing a lawyer would think. So if you tell me that you'd be willing to enter into that, maybe even to join in on the one that's in existence now somehow, that might motivate me. What are your thoughts on that?
Well, the information that's already out there, that's been posted, the main thing that has been going on is me basically defending myself. So.
I know, but what I'm saying is, to the extent you control anything, okay, regarding what's out there to be accessed, if someone had a computer, cell phone device, right? If you would agree to sort of cease and desist or take down, or, you know, and, you know, Mr. Harris has said that, you know, that it is harmed by this, and there are things, I don't know what's out there right now, but stylistically, I usually leave it to people who work this kind of stuff out. Obviously, Mr. Harris and Mr. Needham have worked out a agreed upon stipulation, even though it took a while, but they've given that to me. And I guess what I'm saying to you is you're either going to enter into something like that or you're not. But if you do, I think I'd be more inclined to give you some more time.
I don't have a problem taking down any defamatory content, but however, if that's what it is, defamatory content, but if, as far as information being true or comments being done towards me, I do believe that I should be able to defend myself. So it depends on.
Defending yourself in the lawsuit is what we're really talking about here. I'm trying to give you every opportunity to get a lawyer, and that means adequately defend yourself. But at the same time,
okay,
I do agree, especially given that I've had a number of court sessions now where I've talked with you about counsel, and you still don't have one. That little spectrum, that little needle is moving more towards now the fairness for the plaintiff side on this, because I feel like I've given you a lot of time, fairness, due process, right? So, I mean, you would have to, I think, take responsibility for this and take down or cause to be taken down, anything you control, because like I said, I don't want to continue this case, because on that little needle, go and balance the fairness in the case. You know, I'm not going to have a situation where Mr. Harris now doesn't get his day in court, and items are still out there that could potentially continue to damage his reputation somehow. So it would have to be that there's just nothing out there that could cause that concern in order to give you more time. That's the bottom line on this.
Okay.
So, and what I would mean is, I guess, Mr. Harris, you'd have to, now's the time probably. You generally alluded to this item that's still out there. Can you tell me more about what it is? And maybe we can work out something where the item no longer exists out there. I don't know.
Well, in specifically, Judge, there's a website, equalrightsfordivorcefathers.com, which is now back online. On that website, although it doesn't necessarily direct anything towards me, it is the name of the business which I purchased and is the name which was sold to me. There are links on that that take to his Facebook page and other Facebook pages under other names that say a lot of negative things about myself, about my family, about
let me interrupt you for a reason, because time matters here today. Getting a little late in the morning.
Understood.
Other cases are waiting. What would it be that Mr. Franklin would have to agree to specifically that would give you a comfort level with your concern, that would allow me to give him time to get a lawyer by the end of January? We'd have to move the trial, and I'll tell you what, he gets a lawyer, I'm going to order that settlement conference with both lawyers, and now on that side with you. So that could be a way to resolve the whole mess right now.
Understood, Your Honor.
Okay.
Take down that webpage, that website, and any and all postings that have anything to do with myself or my business on his Facebook pages, all of them. That'd be great, Judge.
Well, what if you took down the website that you have a concern with? And here's what I mean by that. I mean, we can have a court session where I go through all the Facebook posts, but, I gotta say, I'm of the opinion, of course, that some publication of opinion, the First Amendment allows for that. You can have your First Amendment right of expression. So, I don't have a comfort level with saying start deleting Facebook posts and what have you, in a general sense. Okay, but the website that really is the bottom line problem here, this Equal Rights Divorce Fathers website. I mean, to me, if he says, I'll take that thing down, and I'll make sure that I would agree to the extent he controls it, and I know your theory is he's controlled this throughout. I think that's the way to resolve it for now.
I understand, Your Honor. The original publication is referenced in his Facebook posts, which he alludes to, which have been commented on by Mr. Del Casal.
Maybe that
So it's that
aspect of Facebook could be deleted, if you will, just the equal rights part. I mean, because that would be something that, as a conservative approach, keep the status quo we can do.
I understand, Judge.
Okay. Would you be willing to do that? Would you be willing to take down, Mr. Franklin, the equal rights item, and then any links just to that you might have on a Facebook page or some other social media? Would you be willing to do that by way of also signing off on an order that gets created that comes to your attention? Would you be willing to do that? And if you were able to do that, I'll give you up to the end of January to get a lawyer, and I'll move the trial date. You want to do that?
Yes, I could take down the website. There's no links on it, but I'll take down the website.
Okay, so time matters, Mr. Mr. Harris prepare, submit to the court and to Mr. Needham and to Mr. Franklin the supplemented or revised injunction, if you will, that's this would be, and I'll sign it. But I'm going to take your word for this, okay? So that means today, I'd appreciate it to be today, that when you leave court within reason today,
Yeah.
go ahead and take all this down. You'll see the injunction or the paperwork come to your attention. Hopefully you'll sign it and agree to it. But of course, I want you to see it. But what we're talking about is taking down this particular website, taking down links to that website, maybe your Facebook page, and leaving it at that. I'll give you to the end of January to get a lawyer. And we're going to have to continue the case. I'm not sure when we're going to continue it to yet. Do we have another setting that we can give it? Because we'll continue the firm's January 6th date. Maybe we'll have to talk to everybody about when we're going to have that trial at a later time. But under all these circumstances, given that you're going to have a lawyer by the end of January, given that it'll take a little while to get a settlement anyway, you need to actually have a settlement conference. I'm going to order Mr. Needham to grant your request. I'll assume your client's going to act in good faith. I'm further going to assume you're going to get a lawyer by the end of January, and that lawyer and you are going to act in good faith and go to a settlement conference. That's another reason to continue the trial anyway. So, yeah, I guess we could do that. We could bring you back in for a stack calendar call and see if the settlement conference worked or whatever else happened. So what are those dates? January 23rd is not something after January, because I'll make sure he has a lawyer. Yeah. Okay, that's good. February 4th. Let's come back at the court on February 4th at 10:30. Come back at, what day of the week is that, please? Okay, so on Tuesday, February 4th, we're going to be back here. That's going to be another status check on counsel. If you don't have a lawyer by that date, I'm proceeding with the case. I'm not going to do anything else to give time to get a lawyer. If you do get a lawyer after that, so be it. You should always still get a lawyer. But I'm not going to do anything else to afford any more time, basically, to get counsel. You're either going to have a lawyer, that lawyer's going to show up that day. And if you get one, you know, a lawyer sometime earlier than that, of course, because you said by the end of January. As soon as that happens, that lawyer should make an appearance in the court to let Mr. Needham and Mr. Harris know who they are and deal with the case. And participate in the settlement conference that I'm going to order Mr. Needham, you can prepare that settlement conference. Order to grant the settlement conference under the circumstances, because we know when you have it, he's going to have a lawyer, you're going to be there, Mr. Harris is going to be there, so I'll leave it at that. And we'll just go from there. Yes, we have to vacate the firm setting. And okay.
You know, as far as setting up the settlement conference, should I then wait for this status check or wait for this document to be signed, this stipulation, or get on it right away?
You can get on right away. I mean, this is that we have a course that we're going to follow. The course, I hope, works just the way it should for all concerned. Starting with Mr. Harris, the material comes down, so the status quo is kept, and there's no potentiality for further damage to him while this dispute is pending. And I'm depending on Mr. Franklin to do what he said he's going to do on that point today.
Yeah.
I'm giving you to the end of January to your lawyer. So that's why the case is moved, in addition to I'm granting the settlement conference request. And that'll take probably until who knows when, probably late January or early February, late February would be probably the earliest anyway that you're going to get a settlement judge assigned and have your conference, do your briefs and everything else. else, plus they'll give his lawyer time to prepare for that and deal with it and participate by way of filing a brief, all that. So I hope it works just that way. I will say again, though, to make sure you understand that the main, I think, the main factor on this, the main motivating factor, in conjunction with giving you more time to get a lawyer, in fairness, is the fact that there's not going to be anything out there, and that's important. If Mr. Harris sees it, even tomorrow, the next day, or any time, Mr. Harris, you can come back, I'll grant an OST, almost emergency request, you come back into court, and you show evidence that something now exists, I'm not going to be happy about it. So I want to make sure there's nothing out there while this case is pending. Right?
In regard to the stipulation you want, will that involve my need for proving content or?
I think you should at least see it. Sure.
I just want to clarify that.
Okay?
Thank you.
All right, that's what we'll do.
And the motion to reopen is denied, Your Honor, the discovery.
Of course, yeah. It's
Thank you.
denied, without prejudice to bring it back. We'll see what your lawyer does.
Okay.
Okay?
Thank you.
All right.
Case 17, Carlos Alves, William Batson, case number 87849.